its request. But may I, before I go there, just identify 6 features to look out for of that request. Firstly, it's made only in reply. We submit clearly made in reply because he realizes that he hasn't made a case on the papers. Secondly, what he asks for is a court-initiated inquiry, not an adversarial trial where both sides offer their evidence, a court-initiated inquiry. Thirdly, in that inquiry will not be confined to identified discrete disputes of fact. It will be an open-ended inquiry into the question whether he has a cause of action at all. In other words, whether he has a special defense at all. In the fourth place, and this is where the significance of a judicial initiated inquiry is important, he says the court must call a long list of witnesses so that he can cross-examine them. In the fifth place, he says that he must then be given the right to introduce evidence at that inquiry. But he does not suggest or tell us that he has any evidence other than the conspiracy theories on which his application is based. In the sixth place, you will see that he realizes that the spy tapes case and the full bench in the stay application have decided these issues. But he says that the inquiry should be held nonetheless because those courts did not determine those issues by an evidentiary hearing. The place where he raises it in reply starts at page 4162 in paragraph 14, where he says the following. Secondly, a hearing on this plea requires an evidentiary hearing on 2 aspects. The first requires a determination on whether, as a fact, Mr. Downer lacks the independence and impartiality to conduct a lawful prosecution, even though he can prove the formal qualifications. The second aspect arises from the outcome of the first and depends on the gravity of the deviation from the requirements of a lawful prosecution, which includes assessing the degree of prosecutorial misconduct and violations evidencing a lack of independence and impartiality. The second aspect requires an evidentiary hearing on whether I should be acquitted in terms of section 106(4) of the CPA. The evidentiary inquiry on whether I should be acquitted is an inquiry that goes into the section 106(4) process and entails examining whether the loss of title is such that the state has lost the title to present evidence against me in a lawful manner. The focus is entirely on whether loss of title to prosecute has resulted in a situation where the state is legally unable to present a lawful case against me. So what all of that says is a freewheeling inquiry into whether I have a special defense. That's all. Then he says that over the page in paragraph 15, I pick it up in the middle of the paragraph, I am entitled to cross-examine Mr. Downer or any NPA officials on the criminal conduct of prosecutorial violations on which I contend that Downer lacks the necessary title to prosecute. I am advised to apply to the court for to direct an evidentiary hearing on the question of the title to prosecute. So there he says again, the only issue on the agenda is whether I have a special defense. And I must, not only do I want to call witnesses, he doesn't say that he wants to call witnesses, but he does say that the court must call Mr. Downer and other NPA officials to be interrogated. And then at the end of that paragraph, Mr. Downer must be removed as a prosecutor of my case on the basis that there is objective evidence that he lacks rights or title assigned by the Constitution. again, the removal word, which we dealt with yesterday. And then on page 4189, in paragraph 68, he picks up on the topic again. No, and this is where he anticipates an answer that these issues have already been determined by spy tapes and full bench. He says, no court has determined this issue by conducting an evidentiary hearing to determine the scope of political interference and whether such interference violated my right to a fair trial. I skip a sentence and then the prosecutor must present the evidence of Messrs. Hofmeyr, Mshe, of political meddling. It must, at the same time, present the evidence of Messrs. Nguka, McCarthy, and Pacoli, persons who potentially committed criminal acts in my prosecution. So Mr. Downer must firstly be called for interrogation, and then Mr. Downer, the prosecutor, must call all of these other people so that Mr. Zuma can cross-examine them. And then he adds, it's clearly untenable for a prosecutor who's shown a tendency to cover up criminal wrongdoing involving political interference and involvement in foreign spies in my prosecution. Now, and then he says, Mr. Downer is a witness in respect of the following questions, that's paragraph 69. 1, did he speak to persons in the media about my prosecution? 2, did Downer know about Nguka's criminal interference? 3, did Downer know about McCarthy's criminal conduct? Again, all of the conspiracy theories, open-ended questions. And then in paragraph 76, the trial court is entitled to and must conduct an evidentiary hearing on the issue of political and intelligence so that the evidence is tested through cross-examination. And then lastly, at page 4234, paragraph 212 and 213, he says that the steps the court is legally compelled to take. The second step is to examine the merits of the plea, including any objection thereto by the state, if any. And the last paragraph, 213, at the hearing of the application, I will seek an order that the evidentiary hearing be conducted on the issue related to whether I have a defense of political and intelligence meddling. So, there are no material disputes of fact. Mr. Zuma realizes he hasn't made a case on the papers at all. He's not asking for an opportunity to adduce any other evidence. He realizes that his conspiracy theories do not stand up against the credible first-hand refutation of those conspiracy theories. And therefore he asks for a fresh, judicially initiated inquiry into the question whether he has a special defense. Now, it's a process which is unheard of in our law. I realize that this is not a civil case, but it is a case brought on paper, and the way in which courts deal with cases on paper is born of common sense and not the civil nature of the claim. And that is that they firstly give the benefit of the doubt to the respondent under the Plascon-Evans rule. And sometimes, when there are discrete disputes of fact on which the outcome of the application depends, they may refer those disputes of fact to oral evidence. The rule that governs it is Rule 65G, and it says that where an application cannot properly be decided on affidavit, the court may direct that oral evidence be heard on specified issues with a view to resolving any disputes of fact. And I emphasize oral evidence be heard on specified issues. Those are disputed issues on the papers. Now, in this case, there are no disputed issues. There is conspiracy theory and conjecture on the one hand, and credible first-hand evidence on the other. That does not constitute a dispute. And one is reminded in this regard of the point that our courts have frequently made, that there is a big difference between conjecture and inference. If I may just give a reference to the well-known distinction, a reference by the SCA in a case of Knoop, the Afrikaans word Knoop, v. Gupta, the well-known word, surname Gupta, 2021, volume 3 SA, page 88 SCA, paragraph 19, where the court again repeated the quotation that inference must be carefully distinguished from conjecture or speculation and so on.
Is that the Wallace judgment, was it?
Yes, indeed.
Yeah.
And then that same principle was endorsed by the Constitutional Court in Gavric, that's Gavric, Gavric v. Refugee Status Determination Officer, 2019, volume 1 SA, page 21, Constitutional Court at paragraph 115. And the issue there was, and I'm going to read a little extract from it, the issue was whether certain crimes had been committed with political motive. That's got nothing to do with our case. But what also happened in that case is that the accused sought to make a case based on conjecture and speculation, and which the court rejected it as follows. It says, there are no objective or proven facts from which this court can conclude or draw the inference that the offences were political. Instead, the applicant has relied on speculative newspaper articles to make the case that the crime was politically motivated. All that is before us is speculation and conjecture as to the motives behind the crime. Consequently, while there is credible evidence to support a reasonable belief that the applicant has committed a serious crime, there is no basis upon which the court can find that the crime was politically motivated. The same in our case. There is conspiracy theory, that's conjecture on the one hand, credible evidence on the other, and that doesn't make for any dispute of fact. But in any event, as I have said, Mr. Zuma acknowledges by implication that the case does not hinge on any particular dispute of fact. He's not asking for any dispute of fact to be referred to oral evidence. He's asking for the whole case to start again. And he's asking for it to not only to start again, but to be determined by a procedure entirely foreign to our law of a judicially initiated inquiry to determine whether a special defense for which no prima facie case has been made can in fact be established. We submit with respect that that is quite inappropriate and that there is no justification for it. Lord, those are our submissions. May I perhaps just mention one thing? My learned friend and I have at least an understanding that we'll finish before 1 o'clock. But I'm telling your Lordship about it not because I want to inhibit my learned friend, but merely ask your Lordship's indulgence whether my learned friend Ms. Raja and I may leave at 1:45 to catch a plane. My learned friends, under the direction of Mr. Breitenbach, will remain in attendance.
Yes, no, that's in order, Mr.
Thank you.
No difficulty with that. Mr. Mpofu, before you start with your reply, I think I must just hear from Mr. Roux,
Oh, yes.
whether he wants
Yes,
to say anything,
that's correct,
because
my lord.
we've left him out of the picture.
As good.
Mr. Roux?
After long and hard consideration, we decided not to make any submission.
Well, at least you can't say I didn't give you the opportunity.
Yes,
Yes, Mr. Mpofu. So,
Yes, my lord.
sorry, you are then.
just so
It
that
is
we
then
don't
your
have
turn to
another irregularity, my lord. My lord, yes, thank you, my lord. My lord, can I also just start by firstly asking your lordship to excuse my learned junior, Mr. Kulu, who's not here. He got held up, but also to excuse my learned friend, Mr. Masuku, who has to also leave for the same reasons of catching a flight at about 12. I've told him that he must leave as discreetly as possible.
Yes.
So,
No, I don't have any difficulty with that, but hopefully we might finish before then, Mr. Mpofu.
well, I will before 12. No, that's not going to happen.
All right.
Thank you.
Now, I mentioned that more in jest than anything.
Thank you. Yeah. Maybe Mr. Trengove might be luckier than Mr. Masuku.
Yes.
As the court pleases. My Lord, maybe before I start my reply proper, let me anyway, okay, my Lord, I'll have to interrupt myself at some stage. I just thought what I should do, my Lord, is just to quickly dispense with this morning's proceedings from Mr. Trengove, so that we don't have to waste time on that in my reply. Well, he says, my Lord, that what we are asking for is, insofar as we ask for a referral to oral evidence,
Yeah.
which I must remind your Lordship, by the way, of the 5 issues that I put to your Lordship yesterday, was only confined to 2 possibilities. I had said that your Lordship would be able to determine the 1061H leg without having to resort to oral evidence, despite what Mr. Trengove is accusing us of. But I then went on to say, my Lord, that should your Lordship not, on the admitted facts, find in our favor, your Lordship would, in the alternative, have a discretion to refer the remaining matters to trial. And remember, your Lordship, at the end of my
Yes.
discussion, I then said, by deductive reasoning, it's those issues that I'm not saying are admitted, which Mr. Trengove has now listed. He's quite right. Whether he had knowledge of this, that, and so on. Those are the disputed issues. Then the second respect in which we spoke about oral evidence was number 5 of my 5 issues, where I said, and I'm just reading it out. It said the
Section
essential need.
1064.
Yes, in respect of 1064
I'm with you.
of the leg of the proceedings. And again, there we said, my Lord, well, maybe let me take one step back. Our assumption, my Lord, is that although this is a 2-step proceeding, obviously the 1061H finding leads to the 1064, but we're arguing it as one case instead of doing it piecemeal. Yeah. But it's open to your Lordship, for example, to say, I'm going to determine the 1061H. It's like agency and the merits. I'm going to determine the 1061H, and then I'll call you for oral evidence. Or I'm going to determine the whole thing. We're leaving it to your Lordship's hands.
Yes.
But to the extent that we seek oral evidence in respect of the 1064, or to the extent that it might not be necessary, of course, your Lordship can say, look, the admitted facts are in themselves so serious that I'm going to acquit. Then that's the end of it. Or your Lordship can say, well, I want to hear whether he knew about the spy, whatever, allegations or not, before I do that, because that's the one that's worrying me. I'm just...
That's where you contend for a discretion on 1064.
Absolutely.
Depending on what I think you called a range.
Absolutely. A range,
and you
yes.
say that discretion I must find on 1064.
Absolutely. Absolutely. But the real sting of what Mr. Trengove is saying this morning is that what we are proposing is a process that is, I just made a note here, unheard of in our law, foreign to our law. Well, it might be unheard of to him, but our law says at Section 108 of the Criminal Procedure Act, and I'm reading out, if an accused pleads a plea other than a plea of guilty, he shall, subject to the provisions of Section 115, 122, 1413, by such a plea be deemed to demand that the issue raised by the plea be tried. Okay? So, even if it's unheard of to Mr. Trengove, but it's here. So, the law deems that by raising a plea such as the one we've raised, then we are saying ipso facto that the matter must be tried. And we know the meaning of tried. So there's no merit whatsoever in the submissions of this morning. I don't even want to bother Your Lordship by pointing out that Rule 65G has got no application whatsoever to what we're busy with here. Those are civil proceedings, motion proceedings. And I thought we had put this matter to bed between myself and Your Lordship on the 26th of May, that this is not a matter where Plascon events even can be spoken about. But anyway, let alone the GNUOP case of Wallace J and all those things. But more than that, my Lord, and it worries us that our learned friends don't seem to understand the case. We have said we were avoiding exactly all these debates about Plascon events and what have you. When we trust our case, and I spent the majority of the morning yesterday, my Lord, explaining that our case is based not on conspiracy theories or whatever, but on the affidavits of Mr. Downer, on his own version. Forget, I didn't quote anything yesterday from the affidavit of Mr. Zuma, deliberately to avoid this kind of thing, because I wanted to say, this is what they say. So even on Plascon Evans, the case would be based on their version. So I don't know what the complaint could be. But anyway, well, now that that is out of the way.
No, I understood that from your submissions yesterday.
Yes, my Lord, as court, please. No. I'm sure Your Lordship understood.
I listened to both sides, although I might not engage you on it.
Yes.
I will reflect on the.
No, thank you, my Lord. Then I'm fortified that Your Lordship has understood both sides' submissions on that aspect. Then, my Lord, let's now then go to the serious matter.
Just before you get to that, Mr. Paulford, just on a procedural matter, and I want to mention it while Mr. Trengove is also here.
Yes, my Lord.
And I'm sorry to interrupt your argument.
No,
Please
my
forgive me
Lord,
for
not
that.
at all.
One point I didn't raise with you yesterday in Chambers was, as I foresee it from here on, I will hear the argument today, concluding with your argument, and then the matter will be adjourned so that I can go and write a judgment.
Absolutely.
We're at present in recess, and unfortunately due to personal circumstances, I'm not available to start working on it straight away. So I'll need some time. But perhaps Mr. Trengove, while he's here, and Mr. Breitenbach can discuss it maybe with Mr. Masuku while you're on your feet.
Yes.
And just get to some date, say 4 weeks hence, just to allow me time to write the judgment. If for any reason I'm not ready by that date, then I'll communicate with the parties in advance, and we can just, in absentia, adjourn it to a later date. But let's just try and get a date that suits the parties, insofar as it concerns whoever might be here.
Yes.
I would think that possibly lead counsel will not be here to note effectively the judgment, although it's not quite noting, but and you might give consideration too, well, we don't know whether Mr. Zuma will then, by that date, be here to hear it, or whether the parties have some other suggestion.
Yes.
But if you can just please discuss that or debate it, and then when we get to the end of today, in the absence of whoever might be excusing themselves, obviously also in conjunction with Mr. Root, that we have, you can give me a date that we will be adjourning to.
My Lord, I'm sorry.
No. I think
my
they
Lord,
can discuss it.
that's completely in order, I assume.
Yeah, you can tell me.
Us.
You can tell me at the end that the
Yes.
parties have agreed on the following date, but just give me a bit of time,
Yes.
because as I say, I can't start immediately with it. I've changed my plans to accommodate the hearing for these 2 days, and just give me a bit of time so I can reflect on the arguments, and hopefully write a proper judgment.
Thank you. Yeah,
Yes.
My Lord, we're happy with that, especially subject to what your Lordship has said, that date would effectively be a holding date. And of course, in the usual way, the parties usually cooperate.
Yeah.
If there's any intervening issue, we will write to your Lordship.
I'm going to try to make that,
Yes.
call it a deadline if you like, and
Yes.
deliver the judgment
Yes.
because that's what.
Is required,
Yeah.
yes. As a
Sorry,
purpose, yes.
please continue with your
Thank you,
argument.
my
Sorry
Lord.
about that interruption.
Thanks, my Lord. Much appreciated. Yes, I was saying then, my Lord, if we can then turn to the serious matter of the reply on what happened yesterday.
Yeah.
My Lord, we have, there are 5 points broadly that characterized what Mr. Trengove said yesterday. And I will, at first I called them the big 5, but I thought it turned out that might be an insult to our wild life. So I'm calling them the 5 paper tigers. The first one was that the first accused, presented an incomplete and one-sided view of the facts. That we can dispose of very quickly because of the discussion we just had now, my Lord, that we concede that it was a one-sided view of the facts, but it's their side. So it's actually based on what they said to make it easy for them. But Mr. Trengove accompanied that with what a distortion. Well, if it's a distortion, it's what they have said in their affidavits. The second paper tiger was that what we were doing was to malign Mr. Downer for totally innocent conduct. Underline totally innocent conduct. I'll come back to that. And then the third one was that Mr. Downer should be given a medal because he stood up against his bosses. I'll also dispense of that one very quickly at some stage. And fourthly, that he's owed an apology that is, if not a sainthood, by us. And then the last one, which is a more serious issue, was that the application is not an application in terms of Section 106, but a disguised application for stay of prosecution. Because, so the argument goes, title to prosecute only means degree certificates and compliance with the delegation framework of the NPA. Or, as we have termed it, the so-called narrow definition as opposed to the wide definition.
Mm-hmm.
Well, let me start by addressing that one, my Lord, because that, as I say, all these other issues can be quickly disposed of.
Right.
We have given your Lordship a number of authorities, maybe 6, 7, or even more, on which we rely for our contention that the wide or broader interpretation should be preferred. We have also referred your Lordship to the normal rules of interpretation, legislative interpretation, and constitutional interpretation. But Mr. Trengove tells you that no, you must prefer his narrow certificate-based interpretation based on nothing. He hasn't given this court a single authority, a single case in this world where the so-called narrow interpretation is based on or where it was ever applied. It's just a creation of the NPA. Well, but the more serious business, my Lord, about that is that the alleged favoring of the narrow interpretation is based on what I would, if I didn't know Mr. Trengov better, I would have said it's a deliberate, but I will say it's an unfortunate misreading of the Porritt case, which is very clear. That case, my Lord, clearly favors the wider interpretation. And I will demonstrate, my Lord, that case, let me say, like many others, Delport, Musa, Ushekunze, and so on, Nduli, all that, those cases favor the wider interpretation. The unfortunate misreading of Porritt, my Lord, is based on, maybe I don't know whether it's a language thing, but at paragraph 8 of Porritt, which I read out to your Lordship, the following is said. Oh, before I go directly to Porritt, let me say that the other red herring that Mr. Trengov raised was that latching on to the word removal, and again, hopefully, unfortunately, misunderstanding what this case is all about. For that proposition, he relied on what is said at page 7, my Lord, of the founding affidavit, where the following words appear. In the further alternative, that is now like 3 steps removed, and as an independent basis, it says, I'm advised that Mr. Downer SC should be removed as a prosecutor in this matter because he lacks the independence and impartiality required by the Constitution and his oath of office, and under Section 32(1)A and 32(2)A of the NPA Act, and another passage where the one that he read, Mr. Trengov read out, says that because he lacks the title to prosecute, which is a matter I'm going to come into now. Well, my Lord, if you go to page 6 of the founding affidavit, very early in the day, we set out what this case is about. So there should have been no confusion as to what this case is about or what it is not about. We say at paragraph 6, I'm advised that when I plead to the charges against me, I'm entitled under Section 1061H of the CPA to plead that the prosecutor, Mr. Downer, has no title to prosecute. I intend to plead that Mr. Downer has no title to prosecute. This I say because there are facts and circumstances, right, that demonstrate that he lacks the independence and impartiality to prosecute this matter. The independence and impartiality of a prosecutor is a jurisdictional requirement for the right and obligation to prosecute. When a prosecutor lacks these legal attributes, the word I used yesterday, attributes. Remember, I gave 11 attributes. And that comes from a case of Phillips versus Borta, the issue of attributes, which I will go to now. He or she has no title to prosecute. That's what the paragraph 4 of the founding affidavit. Then it says, consequently, his retention as a prosecutor in this matter will infringe my fair trial rights entrenched in Section 35(3) of the Constitution. That's another confusion. When you say consequently, we are making the point I made yesterday, my Lord, of the natural linkage between this Criminal Procedure Act and the Section 106, which is tried. So Mr. Trengov then converts that to say, no, what we're actually doing is a Section 35(3) right, and I don't know, then consequently 106, which is not our case. That's his case. Then we say at 6, alternatively, right, in the event that the word title in section 1061H in CPA is interpreted narrowly, the way they prefer, to mean only formal statutory requirements for appointing a prosecutor, I'm advised that the court should extend its meaning to include the absence of independence and impartiality to conduct a prosecution as falling within the meaning of title to prosecute. We've debated that. In other words, the so-called wider meaning or broader meaning. It is permissible for courts to do this in terms of section 39(2) and 3 of the Constitution. That's the interpretation clause. Furthermore, an interpretation that I contend for is consonant with the section 1064 of the CPA, which entitles me to demand an acquittal in the event of being successful in removing Mr. Downer, which we dealt with yesterday. Then we say, in the further alternative, now 3 ways, then is the part that I read out earlier about I'm advised that Mr. Downer should be removed as a prosecutor and so on. Now, here's all right, I'll come back to that. I thought I would dispense of this Phillips versus Porter quotation. But the issue, my lord, is that Mr. Sengov, although to his credit, he did say there's nothing magical about the word removal. But then went on to want to accuse us just picking up on the word removal. Well, that approach, my lord, is quite frankly perplexing, to say the least. Let me explain it in very simple terms. If one doesn't just latch onto the word removal, and this is a good prelude actually to the analysis of Parity that I'm going to embark on very shortly. What we're saying, my lord, is there's a difference between a situation where there's a case that is brought for the removal of a prosecutor, of a particular prosecutor, who may then be replaced by another prosecutor. I made the examples, I won't go into that. I made the examples yesterday. Let's call that situation 1. To the present situation, where indeed the prosecutor must be removed, but the removal is a prelude to the real business, which is the acquittal of the accused. So there's a difference between a case brought before your lordship for the removal as an end in itself and a removal that is a means to an end. If that can be understood and appreciated, then we will make serious progress. So what we're talking about here, maybe to make it even easier, in case that part is not easy, is that we want, if anything, we want this court to remove, rather than Mr. Downer per se, is to remove his title to prosecute in this matter. Or, as I said it yesterday, whether you can call it a declarative, or to declare that he lacks the title to prosecute. So that's our case, and I think it's much more preferable if we define our case ourselves, because, to quote Mr. Sengov, what a distortion of our case. So let's then go to Parity, because really, I genuinely think that this is where the problem is. Mr. Sengov reads Parity to mean that Section 1061H would be impermissible to be used, even in the case I call type 1, let alone the case, this one. Sorry, my lord. Well, nothing could be further from the truth, my lord. Section 106.1h, in terms of PORIT, may be used even for both types, let alone the fact that we're not in type 1. I hope that much is clear now. And I think it's the words that elude Mr. Trengove are the words not necessary, or that you don't have to. And I tried to explain this yesterday to say, when something is said is not necessary, it does not mean that it's impermissible. It means, I don't know, maybe I can say it in this clause. That is onnodig, unnecessary. Thank you, Frim. Now, that's where I think the problem is. Now that we're speaking in languages that we understand, maybe it will be much easier. Let's go to paragraph 8 of PORIT. It says, the appellants were unsuccessful in their invocation of the provision of 106.1h to challenge the title to prosecute. We already said that also already makes PORIT to be distinguishable on that basis. But the legal facts, obviously, your lordship can distill. And it says, the decision of the court below to remove the prosecutors was not based on their lack of title, but on a different basis, namely that there was an apprehension on the part of the appellants that 2 prosecutors were biased. In other words, what was pleaded in that particular case was not lack of title, but that they were biased. Let's call it the type A situation that I defined earlier.
That's the basis upon which the court or quo removed them.
Yes, the court which was being appealed against. That's correct, my lord. Now, then the court said, but counsel for the appellant submitted in this court that where a prosecutor is found to be biased, his or her removal may be said to be based on his or her lack of title to prosecute. This is what I was saying there, that counsel there, by the slight of, well, not exactly genius because it didn't work, but at least was trying to say, well, it's the same effect. If I've asked for a bias, now that that has been found to exist, then I must be taken as if I've just won the 106.1h leg. Therefore, we must now go to 106.4. Creative, but very wrong. Then it says, the appellants were therefore entitled to demand an acquittal in terms of section 106.4, so the argument proceeded. And this is the important part. I'm going to read it slowly. In my view, that cannot be so. It was not necessary for the appellants to place reliance on section 106.1h for their application for the removal of the prosecutors on the basis that they were biased. In other words, they could have brought it under 106.1h, but it was not necessary. And the example I was making to one of my juniors is that if I'm driving back to Johannesburg and I say, I don't want to pay toll fees, they might say to me, it's not necessary for you to use the
N3.
The N3, yes. You can go this way and that way. But it doesn't mean that I'm prohibited from using the N3 or that it's impermissible. It's not necessary, but it's one of the options. That's the best I can do to explain this. But for the avoidance of doubt, the court then says the appellants did not have to, like me and the N3, did not have to tender a plea in order to place that objection, in other words, the objection of bias, before the court. Indeed, counsel for the appellant advised from the bar that the applicant for removal of the prosecutor on the ground of apprehension of bias was separate in those pleadings, as it were, to the section 1H. And your lordship noted this yesterday, but counsel had agreed that the two would be argued together. So that's what PORIT says. So PORIT, contrary to what we are told here, actually favors the wider interpretation. It says, even in a case of bias pure, the one that Mr. Trengove was wrongly accusing us of bringing here, you may come under 1061H, but it's not necessarily the only route you can take. And my Lord, for the avoidance of any doubt, the Supreme Court of Appeal said at paragraph 17, after doing the whole analysis, but this does not mean that a prosecutor can never be disqualified on grounds of bias or apprehension of bias. Where his or her bias affects the accused's rights to a fair trial, a prosecutor may well be disqualified. And then went through, my Lord, at paragraphs 17, 18, 19, which I won't read again to your Lordship. But it went through the what I distilled from those 3 paragraphs, what I called the 11 attributes. So the SCA then explained why, on what are the disqualifying attributes, let's call them that. So this case is very simple. If we establish from the common cause facts any one or more of the disqualifying attributes, then 1061H order must be granted. Finish and clear. So the disqualifying factors, the court then went on and spoke to them: objectivity, dispassionate, whatever, and all the things that I spoke about yesterday. Where is that thing? My Lord, in Phillips versus Buota, 1995 2 SACR 228W.
Sorry, 95 to SACR?
SACR, my Lord, yes.
And the page?
228, my Lord.
Yeah.
W. It's one of those electronic copies which I don't like very much. But I suppose this is on page 232. It's a judgment of His Lordship, Mr. Justice Hare. He says, my Lord, and I'm just rounding off this issue about the 11 attributes or whatever. It says, it seems to me that the failure... No, let me take one step back. It says, the issue would certainly be more properly have been raised as a plea in terms of section 1061H of the Act that the appellant had no title to prosecute. Then quotes a case and tried on that basis, right? On that basis. So, and then in brackets, section 108 of the Act, which is what I read out in the morning when I started. It says, when the point was raised by the court at the outset of this appeal, counsel for the appellant expressly declined to rely upon it. In other words, she was well advised not to. It seems to me that the failure to take objection by way of pleading to a charge does not prevent an accused from raising it thereafter. In other words, the section 101H can be raised at any stage, and I'll come to that in a different context. Here's the important part, my Lord. It says, absence of title, right? Absence of title or lack of title, or whatever you read from 1061H, in the prosecutor is fundamental to the proceedings. A jurisdictional void which cannot be filled by inaction or even waiver, since the statute only recognizes and empowers persons who possess the specified attributes. Accordingly, the magistrate was correct in his conclusion. His judgment was effective as if it had been pursuant to a plea to a private prosecutor's title. The proceedings are not a nullity when such a plea is upheld, since 1064 provides that the accused is entitled to demand that he be acquitted and so on. We've also dealt with that. But here's what I want to zone in on, my lord. That it says the statute only recognizes, and therefore it de-recognizes or disqualifies those who lack the attributes. So it recognizes and empowers. So it de-recognizes and disempowers and disqualifies and disentitles, whatever, persons who possess or rather who do not possess the specified attributes. That's how simple this case is. So we don't need to complicate it. And then, my lord, the many other cases, the Musa case, particularly the Smythe versus Ushewu Kunze, which use the wider interpretation, but as I said yesterday, also very commendably place, unlike Porret, if there's one weakness of Porret, it is the fact that it does not emphasize the constitutional, well, not in so many words, but obviously by putting those 11 attributes, it talks about the Constitution. But the Musa case and Smythe or Smith are the best cases that show that connection. And if I may just start with Smythe. That's one I've got. And it talks about one of the attributes that we spoke about. We called it to be dispassionate. In this case, they use a different word, which is probably even more appropriate, detachment. So you must be detached from the case and not, be emotionally involved, as it were. And this is what the court said. I'm reading now from 1130 against the letters I.
So which case is that now?
That's the Smythe.
Smythe, yes.
Versus Ushewu Kunze, 1998, 3 SA 1125 ZSC. A prosecutor must dedicate himself to the achievement of justice. He must pursue that aim impartially. So that's one of the 11 attributes. He must conduct the case against the accused person with due regard to the traditional precepts of candor and absolute fairness. So they put the fairness standard even higher, absolute fairness.
What's the paragraph number again, Mr.
I'm sorry, my lord. No, my lord, it's the older cases, so it's the page 1130 against the letter I, my lord.
Thank you.
Then it goes on to 1131. Since he represents the state, the community at large, and the interests of justice in general, the task of a prosecutor is more comprehensive and demanding than that of the defending practitioner. If I may pause there. In other words, the task of the prosecutor is even higher than of a private advocate or a private defending practitioner. It says, like Caesar's wife, the prosecutor must be above any trace of suspicion, not even wrongdoing, suspicion. As the minister of the truth, he has a special duty to see that the truth emerges in court. He must state the facts dispassionately. So in that alone, you've heard about 3 or 4 of the attributes. And then later in that page, it says, expectedly, it is denied by the first respondent, that is the person who was in the position of Mr. Downer. It is denied by the first respondent, he has lost objectivity in relation, that's another attribute, in relation to the applicant, and that it is his wish to harass and embarrass him. Yet the undisputed facts speak for themselves. So that's the point. The undisputed facts speak for themselves. Those are the facts that are taken from Mr. Downer's affidavit. Regrettably, they reveal that the first respondent's behavior has fallen far short of the customary standards of fairness and detachment demanded of a prosecutor. They instill a belief that if the case were to remain in his hands, there is, at the very least, a real risk that he will not conduct the trial with due regard to the basic rights and dignity of the applicant. And then says, I draw attention to the occurrences which have not been denied, and then lists like we did yesterday. Says to one, the first one is the respondent without any foundation accused the applicant of being responsible for this and so on. So those were now the factual foundations. Here, I say, my Lord, this case makes it clear that a risk, so just a risk, and I think the word jeopardy is used in Porret or Delport. The risk is sufficient. Here, we're not talking about a risk of misconduct. We're talking about proven misconduct. We're talking about abuse of the rights of the accused. We're talking about leaks. We're talking about discussions with Mr. Soul. We're talking about the more recent leaks that we've had. We're talking about conducting lectures. We're talking about the crying episode, which shows a lack of the sufficient levels of detachment. So your Lordship's duty is very simple, to look at that catalogue of conduct which is undisputed. And the Lordship must simply then decide whether that conduct, as it is said, falls short or does not fall short of the requisite of what the charge in that case falls short of the customary standards of fairness and detachment demanded of a prosecutor. That's it. That is about it. So the distortion of our case, the distortion of what the cases demand, the distortion of the standard of interpretation that is required, which is the generous and open standard that is in favor of the accused or in favor of the individual. But more importantly, the distortion of what Parity clearly says about the ambit, I think is the right word, of section 1016H, because that's really what we're debating. What is the ambit of that section? And as I say, there's not a single case in this world that favors their narrow interpretation. So your Lordship, in Musa, I won't even go there. The ambit was expanded. Actually, it was not expanded there. It was expanded in the Singh case, my Lord. I'll give you the reference now. In the Singh case, it was expanded to include abuse of court process. And that expansion is not insignificant, my Lord. In the Singh case, Singh, my Lord, is 2009, Singh versus Minister of Justice and Constitutional Development, and another, 2009-1, SACR 87N, in this division. In Singh, it says at paragraph 90, page 92, my Lord. The provisions of section 1061H of the Act do not, in my view, help Mr. Blomkamp's contention, as section 1061H of the Act is also of application when it is contended that that the prosecution constitutes an abuse of the court's process. So, and that expansion of the section 106H ambit was adopted, as your Lordship knows, in the more recent Musa case. So, what our courts have been doing correctly is to expand the definition even further, rather than to constrict it, as Mr. Tangov seeks to suggest. Now, well, if that doesn't put to bed this issue of whether it is the wide or the narrow ambit, then nothing else will. Because it's the SCA, it's all the cases, it's local cases, it's cases outside, it's the Constitution, it's the section itself. So that matter cannot be taken further than that. Now, then, my Lord, we are then told, oh, there's a case of Van der Westhuizen, just for the sake of completion. As if there's any need to convince your Lordship that the attributes that we talk about must come from the as I said yesterday, from the instruments that we rely on are the Constitution, the Act, the guidelines, the UN guidelines, and the policy guidelines of South Africa. Well, my Lord, just for your Lordship's convenience, really, you remember in Port they rely to the case of S versus Van der Westhuizen. That case is S versus Van der Westhuizen's 2011-2 SACR 26. It's an SCA decision, my Lord. And I won't go into all the. I just want for your Lordship to have a reference point. At paragraph 6 of that case, my Lord, is listed. It says the Code of Conduct for members of the National Prosecuting Authority was recently published in GN R1257 in Government Gazette 33907 of 29 December 2010. It contains the following provisions relevant to the for present purposes. Then it lists them. Independence, and then it elucidates. And importantly, the independence says, in accordance with the prosecution policy, and to be free from political, public, and judicial interference. And then impartiality, and then it puts about 9 sub-points there. And then role in criminal proceedings and so on. So your Lordship, it will just assist. I must just point out D under impartiality, avoid participation in political or other activities which may prejudice or be perceived to prejudice their independence and impartiality. And this is the point that Mr. Masuku was making yesterday, that the involvement of Mr. Downer in that case of the DA is a breach of that. Avoid participation in political or other activities which may prejudice or be perceived to prejudice their independence. In other words, even if it was for a good reason, but for a prosecutor to be seen to be participating in a case which has been initiated by a political party, or a partisan political party, which in this case, as Mr. Zuma says, is hostile to him, that just taints the objectivity or impartiality. Your Lordship knows that impartiality is about perception sometimes. So all those are spelled out in the
Code of Conduct.
Yes. Under impartiality, again, it says remain unaffected by individual or sectional interests and so on and public media pressures and so on, and objectivity. Your Lordship gets the gist of the submission. Then, my Lord, Mr. Tengov correctly referred to section 179(2), I'll get now, of the Constitution as the original source. That section, as we all know, again calls for impartiality without fear and favor and so on. And the simple point I want to make, my Lord, is that those attributes that you find in section 179(2) of the Constitution, which cascade to the NPA Act, and are attached to the NDPP, sometimes to the DPPs, are the same attributes, because those persons cannot delegate to Mr. Downer or anyone else powers that are different or wider or than that they possess themselves. So that, again, this shows you that the attributes can be traced from what I've said, the code, from the constitution, from the legislation, and so on. I think, my lord, that point is also clear. So all that militates against the so-called narrow interpretation, because how could somebody be qualified to prosecute a particular case if actually their conduct is in breach of the Constitution or the Code of Conduct or the NPA Act? It's just a no-brainer. Particularly if we, as we emphasize, we are about, if our business is about affirming the Section 35(3) rights of the accused. In other words, he must just be like any other accused, be tried by a dispassionate prosecutor, like the people in the next court next door or in another court. They all deserve to be tried by a prosecutor who's not overzealous. I think that's the word that was used in Smythe, and who is sufficiently detached from the issues. Can Mr. Downer ever be accused of being detached, dispassionate, impartial, objective, and free from the conduct that is complained about here? No. The answer is no. So if that is the case, then he has no title to prosecute. Sorry, my lord. That's a different set of yellow pages. Now, the other point, my lord, which must not be forgotten, and I won't even develop it, is that seeing that this is a jurisdictional point, if you like, or a preliminary point that is raised, the approach that your lordship has to adopt in giving a proper interpretation is to assume that the underlying factual allegations are true, and then apply them to the law, and then see if this is not a situation. In other words, whether the foundations will be proven or unproven will happen at the next stage. But for now, we have to assume that we're dealing with all the allegations, particularly, well, in case of the admitted allegations, your lordship doesn't even have to go through that exercise, because they are assumed to be true by definition. So this idea that this is a 1-0, I'm now moving to the second part. This idea of that argument, the idea that this is a stay of prosecution application dressed up as a Section 106(1)H plea is quite, must just be rejected. It needs to be stated only to be rejected. Firstly, because the only basis for that, as I said yesterday, is that in both cases the person has to go home. I mean, that's a ridiculous basis to say the two things are the same. But we know that the stay of prosecution, my lord, is based on Section 342 of the Criminal Procedure Act.
342A, I think.
Big A, yes, yeah. That's correct, my lord. 342 big A. And the thrust of that section is a complaint about delay, undue delay, or unreasonable delay, and so on, from the cases of Sanderson and cases like that. Here, we're not talking about delay. This has nothing to do with delay. Whether the case had started yesterday, Mr. Downer would still be lacking the title to prosecute, which is a separate matter altogether.
Yeah, stay is not only confined to delay, though.
No. I'm saying the trust. That's why I use the word the trust, my lord.
Yeah.
So the trust. Otherwise, we can go to the section.
No, I'm familiar with it.
Yes. The trust of that section, there can be no doubt about it, is undue delay and what Krechler J. in Sanderson called trial prejudice. Yes. That's what the Constitutional Court, how it described it. So a simple point I'm making, my lord, is that that whole approach in those cases is irrelevant to what we're busy with here. Because here, these complaints would be there whether the case started yesterday or 100 years ago. So the mere fact that, if we're talking about unfair trial proceedings, we could be talking about a whole lot of things. Section 35.3 has got 15 inexhaustible or inexhaustive subsections. So if you have a 35.3 complaint, it could be about everything. It could be about the presence of the accused. It could be about the right to appeal. All of those will be raised at different times. If you're talking about the right of appeal, for example, obviously that comes at the end of the case. But if you're talking about the representation, that's at the beginning of the case. So there's no magic as to whether something is raised at the beginning or at the end. Except for this, my lord, which is another fundamental mistake that the NPA makes. By definition, a Section 1061H attack is raised at the beginning. So unlike, you could raise a thing about legal representation at any stage or whatever, but 1061H is a plea. What is a plea? A plea is something that is done at the beginning of the case. It's not done in the middle of the case or somewhere at the end, although it is said that in one of the cases that I just read out, that if you have that, I assume if you discover some of those things in the middle of the trial, you could raise them. But we all know that ordinarily a plea is raised at the beginning, which is what we're doing. And then, my lord, remember that submission by Mr. Trenkov is coupled with this accusation that he calls it same old, same old. It's the really flabbergasting suggestion that all what we are raising here has been raised before, and therefore we cannot raise it. We are stopped or whatever from raising it again. But that's a fundamental mistake. Because firstly, as Mr. Masuku painfully explained, those cases were based on different causes of action. So at a technical level, that objection must fail. But more importantly, on the substance, my lord, those cases referred those matters to the trial court. It's not, I don't understand how anyone can say, no, you are now precluded from dealing with those matters, which were specifically referred by the SCA or other courts to this court. The trial court, of course, has to deal with it in the normal fashion, which is where we are now. Once the plea has been entered, and then it can be dealt with. Yeah. But again, to Mr. Trengov's credit, he effectively abandoned the res judicata and issue estoppel issues. So he said, no, when we say res judicata, we don't really mean res judicata. And we accept that issue estoppel doesn't apply in South Africa and all that. So unfortunately, that just resulted in a mighty waste of time, because Mr. Masuku would not have addressed those issues. We could have finished this case yesterday if we knew that indeed they were not being pursued. But it is correct that res judicata cannot apply here, first in principle, but for the reasons I've also just elucidated. Then Mr. Trenkov said that the attack on the NPA cannot be translated into an attack of Mr. Downer under Section 1061H. Well, I can only say we agree to an extent. To the extent that we've said that there are there are overlaps between the conduct, for obvious reasons, of the two persons, let me say that, Mr. Downer and the NPA. But again, my lord, we were at pains to focus the 1061H attack on Mr. Downer's own activities, exactly because we agree with Mr. Trengov's characterization. So it was not the NPA, but Mr. Downer who cried uncontrollably in that episode. It was Mr. Downer, not the NPA, which gave the lecture about this case. It was Mr. Downer, not the NPA, that had secret meetings with Mr. Soul. And it was Mr. Downer who leaked, more recently, his affidavit. So if you go through what those 12 conducts, my lord, it's now 14, of course, 12 plus the 2 that are in the supplementary affidavit, and take out what we've called of the 14 acts of conduct or misconduct, take out, or rather do that mental separation of what we call the admitted facts, then your lordship will have no doubt that we're quite aware of the distinction, and we focus on Mr. Downer, as the case of Nduli says, that it is the prosecutor, not the prosecution per se. Although I must say, my lord, that after the expansion of the ambit in Singh and Musa, it's doubtful whether that statement in Nduli still applies. Because remember, my lord, if once you expand it to abuse of process, then you are attacking the prosecution, but you are using 1061H to attack the prosecution as opposed to the prosecutor. So in my respectful submission, actually, even the Nduli approach has been further expanded, but that's not necessary.
Well, the problem there is Nduli's SCA, the others are lower courts.
Of course.
Lower courts, parochial courts, provincial divisions.
Fair enough, my lord. But insofar as they are of any persuasive effect to your lordship, I'm simply saying, maybe I won't put it higher than this, my lord. Your lordship is correct. The Parity is good enough for me to from the SCA to SCA point of view to support the expanded view. But all I'm saying is that the tendency, let me put it that way, the tendency of our courts. Yes. Well, yes, the tendency of our court, the point I want to make, my lord, firstly, is that the tendency of our courts is to expand, but also to say that the Nduli, even though it was not the SCA, such as the AD, but Nduli happened in pre-constitutional times.
Yeah, sorry, forgive me for that, but I mean the court in Bloemfontein.
No. No, my lord, I'm not. But I'm making that distinction for a particular purpose, my lord, which is to say that this happened in pre-constitutional times, the Nduli formulation. So I would say to your lordship, I would urge your lordship to favor the more expanded approach, but also because it's supported by Parity, but also the more recent cases which focused on the Constitution. In 1991, there was no Constitution. That was still under apartheid times. Now, your lordship then said something to the effect, and I want to misquote your lordship, in an exchange with Mr. Trentworth. My job is to determine whether the accused had a fair trial.
Now, my task at the end of the day,
At the end of the day, yes.
remains always,
Yes.
it's a paramount consideration,
Throughout.
that he must have a fair trial.
Fully agreed, my lord.
Yeah.
And then Mr. Trengov said, no, if Your Lordship could allow me then to let's just use, I agree with Your Lordship. Just to say that in respect of Section 1061H, Your Lordship's task then, given what I've said, is to determine also whether the accused can have a fair trial if our accusations are correct.
Yeah, on the wider interpretation.
On the wider interpretations.
Yes.
But on the Parity interpretation, whether the accused person stands a risk or is in jeopardy, I'll refer Your Lordship to where those words are in the SCA judgments. And also on the Smythe versus Ushekunze formulation, whether the risk is enough or suspicion, whether there's a risk or suspicion that there might not be a fair trial. And in our respectful submission, that would be sufficient for Your Lordship to give the protection of the accused. And this, if anything else I say this morning, my Lord, is not going to be emphasized, it is this. Section 1061H, a purposive interpretation of Section 1061H compels Your Lordship to adopt a purposive interpretation, which is to protect the accused. It is a protection clause. It's a clause that was put there for the protection of an accused person against suspect prosecutors or delinquent prosecutors. So if the prosecutor is delinquent, then the trial fails and the accused must be acquitted. That's the gist, really, of the business we're about for the past 2 days. It's the protection of the accused against the likes of Mr. Downer. So, and that's where this connection about fairness and perceptions of fairness and so on. So in a particular case, my Lord, you could have the best prosecutor in the world. But if I am a shoplifter and I go and lift or steal some goods from a shop, and then it turns out, I find out that this person, the best prosecutor in the world, that shop belongs to him or her, or his wife or her husband. Then that person is stripped of the title to prosecute in that particular case. They will remain the best prosecutor of the century, but they cannot prosecute in that particular case because just of that little thing, that the shop that I happened by chance to steal from was their own shop or the one of their uncle or whatever. And those were the facts in Ushekunze, where the brother had been in the camp, or the prosecutor had been part of the camp.
No, I don't think there's a difficulty with that. It depends on the facts of each case.
Yes. No, I'm making it's not even a factual issue, my Lord. It's a principal legal issue. I'm saying even on any facts, the issue is not about the abilities or the mileage or experience and all those things of that person. It might just so happen, and that's why in Ushekunze they say even inadvertently. So you don't even need dolus. It might well be that someone does it maliciously, but they don't have to. It might be something like the one I've just explained. I'm trying to see if I can assist Mr. Tengov.
I think you've dealt now with where are your points.
Well, I started at the end, as it were.
I started with the end.
Yes.
And you've dealt with number one.
Yes. I'm sorry, my Lord, if I can just, I forgot my own number one.
Oh, sorry. No, your own number one was...
yes, I've dealt with number one.
One-sided view was given, and you said
yes, I've dealt with
it's
number
their side.
correct.
Yeah, obviously, but I think it must be meant in a slightly different context.
Yes, I've not dealt with number 2. I'll come to that.
2 about maligning for totally innocent conduct.
Yes,
3 about the medal.
yes,
And let me tell you on that, I'm not going to determine whether a medal needs to be awarded or whether there's an apology that's required. I'm looking at whether the special plea should succeed or not. So I think that, in a very summary fashion, and I hope I'm not doing you an injustice, disposes of points
yes.
3 and 4.
And 4.
5
Yes,
we've
and-
dealt with.
With
So it's really
yes.
number 2, is
So
it?
it's just 2 is outstanding, my lord. Yeah. Well, if we're going to skip the award ceremony, then
The malignancy, you say that malignant accusing Mr. Downer of totally innocent conduct.
yes,
Well, that's part of what I must consider.
yes. My lord, I have a very serious submission.
I
to
think
make.
2, 3, and 4. Okay.
Yeah,
Yes,
yes,
please
yes.
make your submission.
Thank you, my lord. No, your lordship's summary is quite correct. I'm sorry. Okay, well, I'll have to sell my outfits to the award ceremony of the medal. But
Now, those are submissions that are made, but
yes, no, they're
I'm gonna
made, my lord, and
yeah.
I think they were made in serious light. But if your lordship, I'm happy. Well, let me just say one thing about that, my lord. No, I'll say it in a different context. That's fine. Let's deal with 2 then, my lord.
Yes.
Let me just see if I'm not leaving out.
That was maligning Mr.
Yes, yes.
Downer for totally innocent
Yes,
conduct.
Yes,
Now, you obviously disagree that it's totally innocent conduct. I understand.
that's a good guess, my lord.
Yes.
Uh,
So whether it's justified or whether it's maligning, it's neither here nor there. I need to look at what the conduct is.
Yes. Well, my lord, yes. Before we come to number 2, let me just dispose of something, my lord. It's yes. Okay. No, we're moving in the right direction, my lord. I'll approach that number 2 issue in the following way. And for convenience, I'll focus, my lord, on the conduct that is alleged in the supplementary affidavit. Although, of course, you know there are connections between the old and the new allegations. Well, Mr. Trengove, with the greatest respect, performed what I can only call an exercise in what called smokes and mirrors around this issue of the leakage of the document. Firstly, my lord, on their own version again, they say that they leaked. Well, they don't use the word leaked. They say they released, I think is the word they use. They released an unsigned document to a journalist. So an unsigned document to a journalist before it is filed or served and filed, my lord, cannot by any stretch of the imagination be called a public document. That alone is just the indication that this was a leak by. And then they even say, no, we said you can only publish it tomorrow. Well, then that makes it even a bigger leak, because if you are even going to be coaching the journalist as to when it must be published, that's not the job of the NPA. Then Mr. Trengove very, well, I think date error because the affidavit of Mdutwa is dated the 8th. But that affidavit was done on the 9th. And it was
signed on
actually-
the 8th. It says it's signed on the 8th, and in
Yes.
my recollections there's a stamp of
Yes,
the 8th, isn't
my
it?
lord, well, otherwise it wouldn't be an error if it said the 9th. Why would I be addressing this? I'm only
No.
addressing it.
I'm just saying that factually.
Yes, that's
Ex
what I'm
facie, the
saying.
document, it says the 8th, the
But-
date, and I think there's a stamp of the 8th, wasn't there?
Yes, my lord.
Yes.
But, so, my lord, how does that assist? That's the point I'm making, my lord, that the document says the 8th. But I'm simply saying it was... Let me do it like this, my lord.
Mm-hmm.
It is impossible for the document to have been done on the 8th, because on the 8th is the date that I phoned Mr. Trengove and told him about the document. On the 9th, they wrote us a letter to say that if for us to have a deal, quote unquote, I think those are the words that were used between Mr. Trengove and I, it will be necessary for us to do an affidavit, including the doctor's evidence. We then went to solicit that evidence, and the affidavit was served on the evening, 2108, I think it's common cause, 2108 on the 9th in the evening, right? But I don't want to waste your lordship's time. If your lordship say, well, there's a stamp, there's a stamp. I don't know how that happened. I'm sure it will all be explained in the inquiry that the president has instituted on this. But I'm simply saying that to latch on to that fact, and then to extrapolate from the bar that it means that on the 8th we were busy preparing an affidavit. Well, that's a fair chance of that having happened. But let's say, my lord, for argument's sake, let's say it was on the 8th or the 7th or 10 years ago. The point of the matter is that when they leaked this document, they did not know that Mr. Mdutwa is going to submit at 2108 in the evening on the 9th a predated stamped document. That's what the late George Bezos used to call ex post facto justification of the crime. And I use that word advisedly. So when they did the leak, all these good things about that Mr. Tusini was going to attach it and so on were unknown to them. So that does not take away the mens rea or the criminal intent. So the example I give of that, my lord, is if I steal somebody's car and it turns out that the following day they were going to donate it to me, it doesn't mean that my theft is now lessened. Because actually, if I only had waited a day, it would have been my car anyway. So we don't have to be going on about stamps and things like that. Let's just take that shortcut. But more importantly, my lord, the Mr. Downer says that in his own affidavit that Mr. Breitenbach has checked with him some of the facts, and that shows that both of them were involved in this enterprise. Then Mr. Trengove, of course, puts in evidence from the bar to say no, that was sent to the journalists because of COVID conditions and so on. And there's no such thing in the affidavit. And as Mr. Masuku was asked, where is that in the affidavit when he made a certain proposal? Well, those were also just from Mr. Trengove without any basis. But the thrust of Mr. Trengove's submission was that the document was not a confidential document. Well, that is just preposterous, because the document comes from a medical practitioner. Twice in the document itself, it says it's confidential. I had said to Mr. Tengov that it's the strictest confidence, and I accept. Let me just put one thing to bed, that but Mr. Tengov was suggesting that in Mr. Tusini's affidavit, there was a suggestion that he, Mr. Tengov, might have been the one who distributed the document. There's no such imputation. I accept 100% that Mr. Tengov, when the thing was sent to him, in the strict confidence between me and him.
I think the concern was more that it quotes or annexes communication between counsel.
No, well, that can be, because, well, if that is the case, then
which is
then
normally
20 pages of the just give me Downer's answer.
Mr. Mpofu, I don't think much turns on this,
No.
but
Well, my lord, no,
it was recorded.
No, I can't let that one go. I'm sorry. If that is the complaint, then, my lord, what about page 9 or paragraph 31 of Mr. Downer's affidavit? Shortly thereafter, lead counsel for the state and the first accused, Advocate Vin Trenkov, contacted lead counsel for the first accused, Advocate Dalimpofu, to apprise him of the letter and to discuss the implications. So surely that's not the complaint, because that is what they have done in their own affidavit. So the point I was simply making is that if there's any suggestion, anyway, apart from quoting anything, that Mr. Trenkov was the distributor of the document, that is, I want to say it now, my learned friend, Mr. Trenkov, would never have done such a thing. I take it completely at face value that he did not. So, or at least he wouldn't have given me the assurance if he intended to distribute the document. That's not our complaint. Our complaint is that the document was clearly marked confidential by the doctor. And we make the point, my lord, that the confidence is not only the one that belongs to the patient, although that's a serious enough problem, but it's also the confidence of the doctor. The doctor himself marked the thing confidential. Maybe he didn't want his name to be given to a journalist. Maybe he didn't want to be, because in the article, as you saw, my lord, his name is quoted of the doctor. So even his confidence is breached. So that's really the gist of the complaint. It is that nobody can say that you can't. How can you say that if a doctor says it's confidential, you as a lawyer say no, it's not, and that submission is accepted on what basis? And my lord, this, with the greatest respect, is one of the most concerning issues for Mr. Zuma. Every time I spoke to him yesterday after the case, and I could not discuss any issue because he kept on coming to this issue of saying, on what basis is it said that my private documents are not confidential? That information written by doctors, marked confidential, is said in court that no, it was merely, Mr. Trenkov says, merely about the fact that, he says, it merely states that he's suffering from a condition which poses a significant risk to his life. My lord.
Yes.
You know, my lord, one of the big issues about the values of our constitution, particularly the value of Ubuntu, means respect and empathy, being able to put yourself into somebody else's shoes. Anybody, my lord, yourself, my lord, with respect, me, anyone else, how would you feel if your family members find out from a newspaper report that you suffer from a condition which poses a significant risk to your life, and you are told that that's merely, and people, relatives, friends must find that out for the first time because of a leakage from the NPA. Really, my lord, some of these things are just too difficult to swallow. But so there it is. They say, no, why is he complaining? And former President Zuma takes the strongest possible exception to what was done with his confidential information and the way it was treated in this court and described. But no, we owe Mr. Downer an apology, not Mr. Zuma. Now, and what also told that the journalist was told he must only publish in the morning. When what happens in the morning? Because the information is confidential even now. Well, no longer is now because they splashed it around. And Mr. Trengov went as far as to say he takes exception to what your lordship was referring to the reference to the WhatsApp message between me and him. Well, if he takes exception to a WhatsApp message, which actually doesn't have his WhatsApp, it has my WhatsApp, so he takes exception on my behalf, which I'm grateful for. Then how much more about former President Zuma, whose serious health condition is all over the internet as we speak? Then, my lord, that really is a serious matter of serious concern, but for the purposes of this proceedings, an act of very serious misconduct. Then, of course, my lord, the second one. So this innocent Mr. Downer's innocent conduct that we are maligning. This is the kind of thing that he was involved in. Sordid, if you ask me. And it amounts to criminal activity. Then again, I don't even think I need to bother your lordship about the feeble excuses that were made about the insistence to physically examine former President Zuma. Again, Mr. Trengov, my learned friend, was involved in obfuscation, because what actually happened, the letters will show, because we don't have time now, is that they insisted, they even threatened us with contempt of court if we don't allow the physical examination. We wrote back to them and said, contempt of what? This is the court order. The court order was granted. It says may examine, all the explanations I gave yesterday. Given also the discussions between counsel, the bench, and everyone before that order was even granted, this can't be the interpretation. You have to wait for the report. And we basically said, well, you can do your contempt if you want, because I suppose because President Zuma was in jail for contempt, he was fair game now for other charges of contempt, presumably without a trial. But the point we made, it's only after then that protest that they wrote the letter that he referred to, where they said, well, we're not going to insist on an examination if there's no consent and so on. So now it's presented here as if that was the primary position, that, oh, we want your consent and so on. The threats of contempt and all sorts of things are wished away. We can't do that. It's not allowed. But, my lord, I want to say this. Former President Zuma feels so strongly about this matter that he has asked me specifically to point out to you, my lord, that the the misconduct that was that accompanies that matter, and the other matter of Sam Soul, is something that he is taking up with this court. He has already, as your lordship knows, taken it up with the president. The president has referred to the Minister of Justice and the Legal Practice Council, but he wishes to specifically take it up with this court, my lord, because, as I said, Section 41(6) of the NPA prohibits this conduct. And
Section 40?
41(6), my lord. 41(6), my lord. And Mr. Tengo said, at no stage did Mr. I just saw it on TV this morning. He says, at no stage did Mr. Downer or anyone distribute confidential information to Mr. Soul. That's what he said to you yesterday. About this case, yes. Well, that is another exercise in obfuscation. Firstly, in the case, the issue of confidential information and medical information only relates to the most recent transgression, per se. The previous, Mr. Soul, we don't talk about, it might be confidential in another sense, but we're not talking about the invasion of privacy, which is as serious as the one of the medical information. And the reason for that, my lord, is that there's no discrimination in Section 41(6) between confidential information and information, mere information, so to speak. 41(6) says that notwithstanding any other law, no person shall, without permission of the national director, and if there is, we want it to be presented to your lordship, or a person authorized in writing by the national director and DPP, disclose to any other person any information, unqualified, there's no adjective, any information which came to his or her knowledge in the performance of his or her functions in terms of this act or any other law. The contents of any book or document or any other item in the possession of the prosecuting authority. The record of any evidence given at the investigation as contemplated in Section 28(1 for the purposes of performing his or her functions in terms of this act or any other law, or except for the purposes of performing his or her functions in terms of this or any other law, when required to do so by an order of a court of law. Now, here's the important part, my lord, which I've been asked to communicate to your lordship. This conduct, in terms of Section 41(7) of the Act, this is what it says. Any person who contravenes subsection 6 shall be guilty of an offense and liable on conviction to a fine or to imprisonment for a period not exceeding 15 years, or to both such fine and such imprisonment. That means two things. One, it is a criminal offense, and secondly, it is something that carries the heavy sentence of 15 years as opposed to the 15 months.
Yes.
So, my lord, your lord, former President Zuma has said, I must make it clear that if, for example, there's no action with his complaint with the president, or as he says, referring it to this court, then obviously he will then take such other legal steps to ensure that his rights in terms of the criminal law.
Yeah, Mr. Mpofu, on that, I've taken note of it. I'm going to decide the issue before me, and he must act as he might be advised.
Yes. No, well, I'll address a lot.
Yeah.
My lord, I beg leave to hand up a draft order that we've prepared.
Right. What is this now about the date?
No, this is about the case. Back to the My lord, the reason why I was addressing you on this issue was because you'll see in the draft order, we say that order that we want first is declaring that Mr. William Downer lacks the title to prosecute the first accused in the present criminal proceedings in terms of Section 106(1)H of the Criminal Procedure Act. 2, granting the parties leave to lead oral evidence into the issue of acquittal in terms of Section 164 of the Criminal Procedure Act. Your Lordship can maybe scribble there that alternatively, as I explained it earlier, if Your Lordship. And then 3, referring the matter of the alleged breaches of Section 41.6, read with Section 41.7 of the National Prosecuting Act 32 of 1998 to the National Director of Public Prosecutions and the Legal Practice Council for further investigation and appropriate action. 4, postponing the matter to a date when such oral evidence will be led. The fourth one, Your Lordship we've already covered that we will give Your Lordship a date. So, my Lord, that is the relief which we seek, and we seek that relief because as far as some of these issues are concerned, they are the issues that played themselves out in this court. Your Lordship, okay, I'm finishing. I've addressed Your Lordship on Section 108.
I think you've addressed me on the 5 points you wanted to raise.
Yes, on all the 5 points.
All right.
My Lord, yes, coming
That's
back to
it then,
the practicalities, I've just been handed a note that says the NPA suggests 26 October for judgment. Advocate Rue is okay with it.
26th of October. Is it a
Yes.
Friday?
It's a, is it a Friday?
Not a Friday.
It's a Tuesday.
It's a Tuesday. Well, that's fine. Let's keep that as a preliminary
I
date.
think we can keep that as a preliminary date, my Lord. I'm just a little reticent because I know I have a big trial or a big matter the following week, but my opponent is Mr. Trengove. So
Well,
if he's
it's-
okay with it, then
Yeah, what I contemplate, as I said earlier on, I would try and hopefully have the judgment ready by then. If not, then I'll contact counsel, the 3 lead counsel,
yes.
to arrange another date. But it's going to be a date that the judgment will be delivered, assuming that it's ready by then, and it will be presumably noted. I don't know whether who you would instruct or arrange to come and
We'll
note it.
certainly have junior counsel for the noting of the judgment.
That's your call, but
Yes.
that's how I, at this stage, envisage how the matter will develop from here on.
As God pleases, my Lord, that seems to be in
26th of
order. And it's
October.
the same thing from our side, without even checking with my learned friends.
Yeah.
I can assure Your Lordship that if any other issue intervenes, we will communicate in the usual fashion
26th of October. then.
with Your Lordship. Otherwise, the 26th of
Yes.
October is correct.
Yes.
My Lord, in the circumstances, we therefore ask for an order in terms of the draft order, and the further conduct of the matter will then be determined on the 26th
Yes.
of October. We're indebted to Your Lordship about this hearing. I'm glad we were able. Originally, we had thought it would be 4 days. We've been able to do it in 1.5
Yes.
I'm indebted to all my colleagues.
Yes, I'll be grateful to you too. Thank you, Mr.
That's
Mpofu.
good.
Mr. Trengove, there's just one, obviously this is a new document that you didn't comment on before.
Yes.
You ask from behalf of the state that the special plea, the 106(1)H and 106(4) be dismissed,
Indeed.
and they can ask for this, and it'll be considered and it'll come out as to which I consider appropriate when the judgment is delivered. I don't know whether it calls for anything further, but it is new, so I'm affording you that opportunity.
No, we have nothing to add.
Yes, and the 26th then suits for the postponement of the matter, and that's for you as well, Mr. Roo. Yes. Very well. Yeah, I'll take time in this matter then, and to prepare a judgment, and the matter, the trial is adjourned to the 26th of October 2021. You want your person excused?
Yes, please, my Lord. If you
Yes,
can.
and on that day,
Mr.
the
Durant.
representative of the second accused, Mr.
Durant.
Durant, is again excused. Very
Court,
well.
please.
Anything else arising?
No, my Lord.
Very well, thank you.
Yes, God bless.
Court will rise.